Hello, everyone. Today we have the second episode of our two-part series, and we are going to be talking about the Pregnant Workers Fairness Act, or the PWFA. And Rebecca and I are going to go through how it really does change the landscape for how employers should be thinking about accommodations for pregnant employees. Welcome to Off the Clock, the webcast of employment attorneys at Miller Johnson, where we discuss what is happening in the HR world and provide practical insight and advice.
You and I have talked a lot about this new federal law.
Yes.
And how it really is such a significant change, and we haven't been hearing a lot of chit-chat about it. Maybe we'll start that chit-chat today, right?
Right.
Maybe we'll start the buzz. But it really is different. So should we just kick it off about what the one thing it clears up was the one thing that really confused a lot of people beforehand, which is whether pregnancy is a disability or not.
Under the ADA.
Under the ADA.
Right.
So before this act, if we got a call from an employer struggling with a difficult employment situation with a pregnant employee, that would often be where we would start. Right? Is this even a disability?
Does this fall under the ADA?
Do we need to be engaging in ADA analysis? And it wasn't very simple, was it?
No, and that's exactly right. Right. So before the PWFA, by the way, that I don't like that acronym. It's very awkward to say.
I tried PWFA.
It just
You didn't
doesn't.
like it.
No, I that's difficult.
PWFA?
So I don't. Congress needs to come up with names that have vowels in the first part of them.
But to pass an act that every act shall have a vowel.
Yes, exactly.
Yeah.
Anyway, the PWFA it now just answers that question for us automatically, right? Yeah. What it says is that pregnancy is covered under the ADA.
It doesn't say it's a disability necessarily, but it's covered under
That's
the ADA.
exactly right. What it says is employers have to provide reasonable accommodations for pregnancy, even if the pregnancy doesn't have any complications or doesn't rise to the level of a disability. Okay. And I really want to make that clear because I've seen a lot of confusion on that.
Oh,
right?
yes.
To your point, in the past, HR folks have understood that pregnancy could fall under the ADA, but only if there were complications or other things going on such that it became a disability, right? So that's how people are thinking about it. We got to shift that thinking and just have all of our listeners understand clearly that if you hear pregnancy, you have to provide a reasonable accommodation as the ADA would require, and we can stop thinking about what else is happening with the pregnancy and whether it's a disability. It just is covered.
What is savings on legal spend?
Yeah, right. They're trying to put us out of business.
The whole first hour of our conversations in these situations was figuring out whether the situation was covered by the ADA. Because it is a physical thing happening, right, to the employee, which does carry with it some, sometimes restrictions, things that were not necessarily abnormalities with the pregnancy or high-risk pregnancy. So it was sometimes very difficult to parse out, right, whether the pregnancy was covered by the ADA or not.
That's exactly right.
So
now
question
it just
answered.
Is. Question answered, just like under the FMLA.
Yeah.
The FMLA says pregnancy is a serious health condition, period, end of story.
No more mental gymnastics on that.
Now the same is true under the ADA.
So this is also, just side note, as far as I'm aware, the first time a non-disability has been covered under the ADA. So again, it's not defined as a disability. Right. They're just saying disabilities are covered and pregnancy is covered.
Yes.
So I find that fascinating.
It's interesting. Yes, that's exactly right. And that's what I'm hearing in general. I'm reading and hearing a lot of talk centered around that idea. Okay. But that's not the most interesting part.
I don't think it is at all, because that's easy, right? We just covered that, and I'm looking at our timer in 4 minutes, and we can barely say our names in 4 minutes. So there's not much to talk about with that, right?
Yeah,
but what's the really interesting
part? The interesting part is a piece that I think a lot of people are missing, okay? And that is the PWFA also has a different definition for what it means to be a qualified employee under the ADA. Okay, so once I say that, we probably need to take a step back and revisit what does it usually mean to be a qualified employee under the ADA and remind our listeners of this, right?
Some of us may need a reminder.
Well, not everyone wakes up ready to talk about the ADA, right?
Who are these people?
Yes, exactly. Exactly.
Okay, so so how does it normally work?
This is how it normally works. Under the ADA, there is an obligation to provide reasonable accommodation to employees who have a disability or a mental or physical impairment. But the employee always has to remain, quote unquote, qualified. Okay? And the ADA defines qualified as able to perform the employee's essential job functions. Okay. Now, this is a really important point. And in almost every situation I talk to clients about involving reasonable accommodation, we talk about this, right? Because what it means is that if what the employee is asking for means they can't perform their essential job functions, then we don't have to provide that for them.
Got it.
Another way of saying it is sometimes we get requests for accommodations that really are just requests to not do parts of a job that are essential. Right?
Sounds good to me.
Yes.
What could be the problem? No, yes, I agree with you. That's why we get into those. So if anyone has talked to me or to you, we talk a lot about what are the client's essential job functions.
What are the essential job functions?
Job description, et cetera, et cetera.
Exactly. And that is a critical piece of that reasonable accommodation process. And a good reasonable accommodation process really always starts there, right? Yep. What are the essential job functions? What's this person asking for? Even if we give them that, are they going to be able to perform their essential job functions, or are they really just asking, again, not to do important parts of their job?
Right.
Examples might include employee just is asking to be late to work to be tardy every day. Okay, that might fall under the FMLA, but if the employee is not eligible, that would likely not be a reasonable accommodation because regular and predictable attendance is an essential job function.
Can we just pause on that right now and just as a freebie for everyone that tuned in today? Regular and predictable attendance should always be listed in your job descriptions as an essential job function. Yes.
Right.
Okay.
Correct.
There is a free little tidbit from Sarah and Rebecca this morning. Yeah. Okay. So how does this pregnancy...
Okay, so here's the deal.
Well, change that.
It has a different definition of qualified. Okay.
Fascinating.
So it starts out just fine. It starts out saying qualified means you can perform your essential job functions, but then it has exceptions to them. One of the exceptions is that if an employee can't perform one or more essential job functions now, but could perform it in the near future, that employee is still qualified.
In the near future.
So let's think about that
after
for
pregnancy,
a minute.
Sarah?
Okay, so
what are we saying?
So the PWFA doesn't define in the near future. It doesn't say what they mean.
Oh, good. There's still work for us.
That's right.
Excellent. Okay.
The EEOC is obligated to come out with guidance by the end of the year.
Okay.
But I'm just going to go out on a limb here, and I'm going to make a prediction. Are you ready? That the EEOC is going to say in the near future means within 9 months.
Yes, I agree with you completely. Yes, obviously. I mean, I don't know why else that would be part of this act if that's not what they meant.
So
I don't know why they didn't just say it, though.
Right.
But
okay. So
Congress.
What that means, let's just make sure everyone's following this thread, right? What that means for our listeners is that this idea of being qualified and having to perform your essential job functions in order to be qualified is is not a focus when pregnant employees are requesting accommodations.
Got it.
Because they get this exception. They can say, well, I can't do that part of my job now. But I can in the near future. Because conveniently, we know pregnancy does end, right? Thank God.
Thank goodness.
Thank God.
It's two people that have been pregnant.
We know pregnancy does end. And so we know if a pregnant employee can't perform her essential job functions because of the pregnancy, we know she probably will be able to do so in the near future.
And this new definition only applies to pregnant
Only
employees,
applies to pregnant
other individuals
employees.
who qualify under the ADA for other disabilities, or I should say for disabilities, right? Okay.
Right.
So what does that mean? So we skip over, so let's just think through when a client has an issue. We skip over the discussion of whether the pregnant employee qualifies.
Oh, whether they qualify. That's right. We skip over that.
And then we would normally get to, are they qualified?
Yes.
So we are going to speed along through that.
Yes, that's right. I don't think we skip over it, but it is not going to have the same element. It's not going to have the same meat. It's not going to have the same weight as it does when we talk about a reasonable accommodation process for employees with disabilities by any stretch of the imagination, right? So when I read that in the law, I went, time out, right? Our clients, our listeners need to understand that they can't just apply their same reasonable accommodation process to pregnant employees that they apply to employees with disabilities. And that is, I think that's a really, really important piece of information for everyone to have.
I completely agree. So when you have a pregnant employee, do this.
Time out.
Do this there, Willey.
Time out.
Time out, pause, and think, how are we going to think about this differently? How is this interactive process going to be different? And the first way it's going to be different is that, right?
That's exactly right.
If they can be qualified in the future within a certain time frame, short period, what was the phrase that?
In the near future.
In the near future,
yes.
Then that is not a reason to turn down, right, the proposed accommodation right now.
That's exactly right.
Okay.
So employers still don't have to provide accommodations that would pose an undue hardship, right? That definition is the same.
Okay.
It applies the same definition as
something
the
is
ADA.
Something
That's
is
the same definition.
Okay.
And also, the ADA never requires employers to allow somebody to work if they would pose a risk to themselves or others, right?
And that hasn't changed.
That has not changed either with regard to pregnant employees. So I think from a very practical standpoint, when we're working through accommodations for pregnant employees, the bulk of the time, the bulk of the work is going to be spent thinking about undue hardship and risk rather than whether an employee is qualified. And it's sort of the opposite for how that usually works with regard to employees who have a disability and are requiring an accommodation because of a disability.
And what we know that might be lost on some of our listeners, let's just say it out loud. Undue hardship is just a harder standard to me, right? We would, when we are working through these issues, if we can answer the question on qualifications, we would rather do it there than get to undue hardship.
That's exactly
It's not that
right.
we can't argue undue hardship, and it's not that employers can't win on those, and it's not that there aren't genuine undue hardships. But it's a little more significant of a burden.
It's a high standard, and it's the employer's burden to prove undue hardship.
Yeah.
Whereas arguably, many courts have held it's the employee's burden to prove they're qualified.
Yeah.
Does that make sense? So yes, from a legal position, it is, those arguments are going to be more difficult to make for pregnant employees. And I will just say, I mean, if we can predict one thing, I think for almost certain, it's that employers will have a pregnant employee at some point or another, right? And almost certainly will have a pregnant employee who has some sort of physical restriction.
Yes.
Or requests an accommodation.
Right.
And so I would encourage our HR folks to to be thinking through ahead of time what that process is going to look like for pregnant employees and make sure the individuals who will be handling those really understand the nuances of this law.
This is a good opportunity to pause for PSA.
Yeah.
And making sure managers and supervisors are trained.
Well, that's a good
to get
point,
HR
too.
included at the very, very front end of when a pregnant employee asks really for anything, right?
That's right.
We cannot. It's not reasonable to expect every manager and supervisor, right, to be completely up to speed on the ADA and the process, and it just changed again, right, et cetera, et cetera. But what we can expect is for them to turn to the experts, which in our organizations are our HR team, right? And we can expect our HR teams to be up to date and on top of it.
Great point.
So if we haven't done training for our managers and supervisors about medical issues, and now we can add pregnancy, in the workplace, this is a great opportunity to do so.
Yeah. The other thing I'll add too is none of this changes the other law that protects pregnant employees, and that's a discrimination, that's a prohibition against discrimination, right? We've had a lot of case law in the past several years centered around the idea that we can't treat pregnant employees worse than our other employees. So as we're working through these requests for accommodation, okay, we now know that it will fall under the ADA, but we also need to be mindful not to be discriminating against pregnant employees, right? There's been lots and lots of lawsuits filed on the theory that an employer provided non-pregnant employees certain accommodations or even light duty work, but is refusing to do that for pregnant employees. So that's another layer that I want to make sure is not forgotten as our listeners are thinking about a process.
Okay, so we've just talked a lot about a lot of law. Let's just go through some practical examples, just maybe one or two, so people can get their heads around.
Yes, let's put it into context. Work. Yes, exactly. I think that's great.
Yeah, so let's talk about, and this is about no client in particular. It's a very common situation in a healthcare industry. A nurse who is pregnant and then has a lifting restriction, which is very common with pregnancy, again, aside from any complications with pregnancies.
Yes, that's a great example. That's a great example.
So if we had a healthcare client, Sarah, call you and say, right, I have a bedside nurse, let's be particular, a bedside nurse who does have to be able to help lift patients as part of her essential functions, and now she has a lifting restriction. How would you walk that client through the process?
Right. So that's such a great example, right? And let me say first that if that nurse had that lifting restriction due to a disability, we would be talking about whether or not that nurse would be qualified. In other words, can she perform the essential functions of her job to provide direct patient care at the bedside if she can't lift more than, let's say, 15 or 20 pounds. Yeah. If any of our listeners are in healthcare, right, I can hear lots of echoing of voices saying, no, she cannot perform her essential job functions because providing bedside care not only involves having to move patients, help lift patients, help them ambulate, walk to the bathroom, but also even having to catch patients from falling, et cetera, right?
Yeah.
So this is a great example of how that analysis would be different for a pregnant employee, right?
So the analysis you just went through, let's say she had a back problem.
Yes.
We would say, well, you can't perform the essential functions of your job.
And we would go to, would a leave of absence help? Is there a different open position that you could perform instead, et cetera, right?
So same nurse, it does not have a back problem, but is
instead
pregnant.
is pregnant.
And has the same lifting restriction.
Right.
How is the analysis different?
Right. Well, the analysis doesn't stop at the qualified question.
Okay.
Assuming that her inability to lift is based solely on her pregnancy and that her pregnancy will end in the near future, right? Then that's not a relevant consideration. We can't stop at qualified. But, and this is important, that healthcare employer can still look at whether it would be an undue hardship or a risk to the employee or others to allow her to provide that direct patient care by the bedside if she can't lift.
And others could be the patient in this example.
It could be a risk to the patient. It could be a risk to the employee. It could be an undue hardship. I would argue it's an undue hardship on that organization to have to put an employee in that position doing work if she can't help catch a patient if a patient falls, for example, right? If there's an emergency.
Okay.
So there are arguments to be made there, but you can see how the analysis is different and the communication with the employee is different.
Got it. Perfect. Okay. I think that just giving the example probably helps clarify a lot for people. All right. Let's talk about what we hope people take away from this episode, because again, this was a lot to talk about in one episode. So let's start with the policies. Right. We love talking about policies because HR loves talking about policies, right? And organizations have lots of policies. The big question that's come up over and over again is, do clients need a new policy just on pregnant employees?
That's a great question. Personally, I think that if an organization already has a policy on accommodations, which is often the case, right?
If they work with us, it is.
Yes, exactly. If that's the case, then I would say it would be fine to revise that policy to make sure now that reasonable accommodations are provided not just to employees with disabilities, but also to pregnant employees, and giving them the same information about where to go if they think they need an accommodation or would like to make a request, etc. That would be fine. And frankly, I don't like to over policy things, right? So I would prefer to have a policy like that and then have put together specific internal HR guidance or protocols about how to handle requests for pregnant employees. Does that make sense?
It does.
Have that be an HR document. Some employers have handbooks with a different approach, and that is they have policies that apply to anything and everything, and HR sort of uses the handbook as their process document as well. If that's the case, then that employer would probably want a specific policy on how requests for accommodations work with regard to pregnant employees.
Yes. And another reason to have it as a separate call out in a handbook may just be as a way to show support for pregnant employees, right? You want a pregnant employee to know where to turn, and find easily what she needs to know. I can imagine in handbooks, having just a whole section now about parental leave, pregnant employees, the Pump Act, right?
Just call it babies.
Support for growing families, right?
And not even babies, I suppose, right? Like, could be because it could apply to adoption and potentially adoption of older children, etc. So
supporting your family to grow, something like that could be kind of fun.
And I'll just say this is our third episode now on that topic. I don't know if you've noticed, but we talked about parental leave.
Yeah.
We talked about the Pump Act, and now the Pregnant Workers Fairness Act. So we've had a bit of a theme.
Well, thank goodness we cannot grow our families simply by talking about it.
Yes, right. Amen.
With that, let's get back to work.
All right. Thanks, Rebecca.
Okay. Bye, Sarah.